Hi, welcome to Trials Deconstructed. My name is Evan Walker. I'm a solo plaintiff attorney here in San Diego. Briefly, a little bit about me. I've been doing plaintiff work since 2015 is when I opened up my own practice. About 60% of my practice is serious personal injury cases. The other 45% are kind of high-end property damage cases, either first-party claims or third-party claims. Previous to that, I worked as a defense attorney on the East Coast and then as a defense attorney down south in New Orleans defending Hurricane Katrina claims. Why am I teaching about trials? So my trial experience is very limited. So let me be honest with y'all. So I think when I was a defense attorney, I had 1 or 2 second chair trials, and saw the partner kind of do his thing. And then on my own as a plaintiff attorney, I tried my first jury trial in January of 2020, so right before COVID. And I lost. We lost big time. So that was quite an experience. And I'm sure you've heard the saying, you learn more from your losses than your wins. And right now I don't have any trial wins, but I certainly learned a lot about that trial loss. And so what I wound up doing for the rest of 2020, as COVID, started causing havoc, and then throughout 2021 up until today, was really taking a deep dive into trials and deconstructing trials. And what happened was, at least during the start of COVID, there wasn't a lot going on. And so there was a large amount of information online from fantastic trial attorneys kind of breaking down every part of a trial. So I digested that completely. I read tomes and books and a lot of information, inches thick, of different parts of trials and strategies and what works and what doesn't. And so I really spent 2 years taking all of that stuff in. So what this CLE is going to be is hopefully a very helpful, succinct representation of all the information that I learned during that time. But I don't want to come across and say, oh, well, this is just armchair theoretical, because it was born out of my experience of going and doing that trial and losing and saying, I really got to spend more time doing this and understanding this. Also, since then, I've, kind of put these practices in use for cases since that loss in January of last year, and kind of worked things up all the way out to trial and wound up getting better results, because although the other side doesn't tell me, I think one of the takeaways is you can see that you actually kind of know what you're doing, and you know how to work a case up, and you know what's going to be important and what's not. So that's really the point of this CLE and why we're teaching it. So Trials Deconstructed. The takeaway from the very beginning, trials are rare. Anecdotally from my own experience, but I want to even go beyond that. So California publishes every year the Court Statistics Report. It's by the judicial branch. We're not going to talk about 2020 because that was an outlier with COVID. So the most recent, I think, accurate statistic is going to come from 2019. So as of 2019, out of all the civil cases filed in the state of California, 79% were disposed of before trial. So that's going to be settlement. I'm sure there were some dispositive motions like summary judgment or demurs, things like that. But 79% of cases never got to trial. Of the 21 that did go to trial, 89% of those were a bench trial. 8% of those were a trial de novo. Then the remaining 3% were actually civil jury trials. So what does that mean? Well, that means here in California, which is probably the most litigious state, less than 3% of all civil actions filed actually went to trial by jury. And that's the reality. The reality is there just aren't a lot of trials. However, I still think that trials do happen, and that if you practice in litigation, at a minimum, you need to have at least a bird's eye view of what a trial is, broken down into its parts. And that is the point of today's CLE. So we're going to take a bird's eye view of trial. To give you an idea of a roadmap, we're going to talk about very briefly pre-trial, then we're going to voir dire, then we'll go into opening statement, direct examination, cross-examination, closing argument. So let's go ahead and get started with pre-trial. So something to keep in mind when you're talking about pre-trial, you want to think about what are the types of evidence, how do I get the evidence in, and how do I keep the other guy's evidence out?